All right, so I'm going to get started. So thanks everyone for joining us today. I am Sharon Campo, supervising attorney here at Legal Services of Long Island. And today we have our wage and hour training with John Batanchiev, who's one of our supervising attorneys in our Nassau County office, and Jacob Mortenson, who's a law graduate in our public benefits unit in our Nassau County office as well. So everyone can see my screen, right? Just to make sure. So just as a reminder, we recently, and back in September, it's actually going by pretty quickly, we changed our name from Nassau Suffolk Law Service to Legal Services of Long Island. Same organization, just different name. So just a little reminder there in case you hear our name in other places. Some housekeeping, just if you can, keep your microphone muted so that way we don't have any background noise. If you have any questions, feel free to put questions in the chat and we will address them throughout the presentation. We will have polls throughout the presentation just to keep it fun. And we do have a survey at the end of the presentation. If you don't mind just filling that out quickly, I'd really appreciate it. So if you're unfamiliar with our organization, Legal Services of Long Island is the largest provider of civil legal services here on the island. All of our services are free for those who are eligible. It includes direct representation, phone consultations, brief services or referrals. We do handle over 6,000 cases every year. And we have offices in Hempstead, Islandia, and Riverhead. And we have attorneys, paralegals, and social workers as our case handling staff. And we do have partnerships with community agencies as well, such as Empire Justice Center and Brighter Tomorrows. And these are our 3 office locations. We do accept walk-ins. The best way to be screened for services for clients is to call the office that's closest to you or in your county. So for example, in Nassau County residents would want to call our Hempstead office to be screened for services. And in Suffolk County, you'd want to call either the Islandia or the Riverhead office. Typically, Riverhead handles cases that are east of 112. But of course, if you call the wrong office, we'll, still screen and transfer to the correct office. And we have about 20 different programs ranging from family law areas specifically for Suffolk, disability and health related units, whether it's mental health or our education and disability rights project. In a few weeks, we will be hearing from our ICANN unit, which helps folks who are on managed long-term care. We have housing units that assist folks who are being evicted in both counties, Nassau and Suffolk, as well as our foreclosure defense project, which assists folks who are at risk of foreclosure. And then we have other areas of law, such as consumer debt or veterans' rights or human rights, but we also have different specific units that help with certain populations, such as our senior citizen project or our adult care facility unit. So if you do have any questions, you want to find out more about the different units, feel free to check out our website. It's legalservicesli.org. And we have descriptions of all the different units. And we also have our YouTube channel, which goes through quite a few of our units as well into a little bit more detail. Our legal support center for advocates is specifically for advocates like you, who folks who are caseworkers, maybe work in an elected official's office, if you're an attorney, if you volunteer for your church, anybody where you're helping a client, and you have a question about whether our organization would take on a specific legal issue, or you have a question like, oh, this client needs a power of attorney, or just a variety of different potential legal areas that might come up, we try to help you out. Whether we're making a referral, give you the legal information over the phone, or making referral within our office to a specific unit. We also host the community trainings, such as we did today. We'll come to organizations and provide trainings, to provide information about our organization. We also publish newsletters. I send out advocacy tips every month. So we have a lot here. So we have our extensions listed here, and just remember that this is only for advocates. It's not for clients. Unfortunately, when clients leave messages, which we do get messages left in our voicemails, it takes a lot longer for them to get the services that they need because we're not case handlers. They have to be sent back to reception. So it's easier if you're going to make referral to clients, make sure you give them the direct line so that they can be screened and faster. Okay, so really quick, we're going to do 2 polls. First one is what type of advocate are you? And the second is, have you ever called the Legal Support Center for advocates? So let me just bring up those polls. We have an idea of who's with us today. So first one, what type of advocate are you? If you don't mind just taking a few seconds to answer the question. Okay, a few more seconds. Okay, I'm going to end the poll. Let's see who is with us today. So we have a bunch of attorneys, a bunch of nonprofit employees, paralegal. So welcome. Appreciate you coming here today and learning from us. So our next poll is, have you ever called Legal Support Center for advocates? Let me see if I can launch this. Hold on one second. I did something wrong. Okay, so if you could just take a moment to answer the question. First is, yes, I have Kathy Lucidi on speed dial. Yes, once in a while, or no, but so happy to learn about the program for advocates. Okay, a few more seconds. Okay, I'm going to end the poll now. Okay, so about 7 of you have heard of us, and you call once in a while, so thanks so much. And then a bunch of you, 12, are so happy to learn about the program because you haven't heard about it before. So feel free to use the program. Once again, it's for advocates only. Feel free to give us a call if we can help you out or help out your one of your clients or constituents or folks that you're volunteering with. Okay. All right, and then here's our website. Definitely take a look at it. You can look at our, you can just sign up for our legal lessons, look for our trainings. We have self-help resources as well on there. And then take a look at what other events we have. And then we have 2 upcoming presentations that you may be interested in. Next week, we have the basics of applying for SSI for children. So that's going to be next Friday. And then on April 9th, we have our introduction to ICANN and community-based managed long-term care. So definitely feel free to sign up for those presentations as well. And just a note that although we try our best to keep all of our legal educational materials up to date, any information contained in our materials is not legal advice, it's legal information. Legal advice depends upon the specific facts of each situation, and our materials cannot replace the advice of competent legal counsel. Just keep that in mind. Okay, and with that, I'm going to pass it off to, I believe John is starting with first.
Thank you, Sharon. Good afternoon, everyone. Thank you for joining us on this this important topic. Just wanted to introduce myself and the units that I supervise in case that is useful for any of the advocates out there. I'm a supervising attorney in our Nassau County office in Hempstead for our Veterans Rights Project, our Mental Health Law Project, our Public Benefits Project, and our Human Rights Project. So today we're going to talk about wage and hour violations. just a history. This is a new area for our organization to be taking cases on. We have not had taken these types of cases on previously in recent memory. This is going to be limited. Our representation for clients will be limited to Nassau County residents at this time, and we'll be helping them file administrative complaints with the Department of Labor. But a little bit of an introduction about this area. Employee rights cover a wide range of federal, state, and local laws and regulations. Today, we'll be covering just New York State wage and hour violations. And there are various ways that an employee can enforce those rights through administrative agencies at all levels of the government, private lawsuits, and sometimes even criminal proceedings, depending on the nature of the violation. This presentation is only going to be discussing the path to request New York State Department of Labor to investigate and determine whether a wage and hour violation has occurred. Next slide. So important distinction, this presentation is going to be covering the rights of an employee. There is a lot of debate and over the definition of an independent contractor, but we won't be covering that in this presentation. So this presentation is going to be focused not mostly, but all exclusively on the rights of an employee with wage and hour violations. Okay. So often wage and hour violations are good faith mistakes by the employers done either due to an error or ignorance of the law. While that does not mean that this is acceptable, it is important to note that examples of how employers may try to hide wage and hour violations are only the most extreme examples, and some employers may employ these sorts of practices without realizing they're against the law, especially small business owners. Next slide, please. Oh, okay, so we have a question here, a poll. What is the current minimum wage on Long Island for non-tipped workers? Sharon, do we have like an actual? Okay, perfect.
Yep, I just launched it.
Great, thank you.
Okay, a few more seconds. Get your guesses in. Okay, I'm going to end the poll. I'll share the results. Okay, so the correct answer is $16.50. So for Long Island, the minimum wage for non-tipped workers is $16.50. And the rest of the state, which does not include New York City, because New York City is also $16.50. The rest of the state, it's $15.50. $7.25 is the federal minimum wage. That hasn't been changed since 2009. And the lowest minimum wage is $5.15, which is in Georgia, but that is for workers who are not covered by the Fair Labor, and I'm going to get this wrong, Jacob, correct me, the Fair Labor Standards Act, I think it was, which is a federal law. Is that correct?
You got it right.
Okay, perfect. So just so you have an idea of where New York is and where the rest of the country is.
Great. All right. So the first topic we'll be going over is what most people think of when they hear there's been an hour and wage violation, which is a minimum wage violation. And this is what it sounds like, that someone has been paid less than the legal minimum wage. The minimum wage can vary from industry to industry and county to counties, and the most up-to-date information can be found on that link. As Sharon mentioned, the right now for Long Island and for New York City and Westchester, the minimum wage this year is $16.50. It does differ for tipped service employees and tipped food service workers who have where there's a tip credit that's factored into the minimum wage for those industries. But ultimately they all equal up to 1650 for all of that. So and we'll talk about tip credit later on when Jacob's speaking, but just so you know, for tipped service employees, which are typically employees in the hospitality industry, the tip credit towards the minimum wage is $2.75. And for the food service industry workers, and this is again just on Long Island, is $5.50 is the tip credit. So the cash wage is the difference between that and the tip credit to get you to the minimum wage. But we'll be going over a little bit more of that in more detail later on. But this is again what most people think of when they think of a wage and hour violation. And all employers are required to pay a state mandated minimum wage. Does not matter whether they're a small business. There's no exemptions to this law. As long as you have a one employee that you're paying, that's not yeah, that they have to be paid at least the minimum wage. Next slide. So here's an example of a situation that would rise to the level of a violation. Pete's Pizza pays $10 an hour for their work to their workers, which is less than the local minimum wage of $15. In this situation, it's $15, just to make the math easier. Buddy worked for 15 hours this week and has earned $150. To ensure Pete's Pizza does not raise suspicion if their books gets checked, Pete logs in their payroll software that Buddy worked 10 hours instead of the 15, which would then get him to that $15 an hour rate if using the 10 times 15. So accepting a lower pay rate does not prevent someone from raising this claim. You cannot waive the right to a minimum wage. It's common for employers to sometimes ask their employees to sign a document stating that they're waiving certain rights when they accept employment, particularly around wage and hour, minimum wage. These agreements are often unenforceable. So if you know of a client that has this type of situation, we recommend that they speak to an attorney to see if that agreement is enforceable. Next slide, please. And now we'll hand off the mic to Jacob.
Thanks, John. Hi, everybody. My name is Jacob. I'm a law graduate in the Public Benefits Unit in the Hempstead office. So we're getting to tip credits now, which they can be a little confusing, so bear with me here. So essentially, certain employees are paid well below what we generally consider the minimum wage and have their income supplemented by tips. You know, the typical example of this is a waiter. Now, in New York, we handle these pretty differently than a lot of other states. So functionally, these employees still need to be guaranteed a minimum wage, but employers can credit part of that minimum wage against their tips that an employee would receive from customers of the business. So John went through what these typical amounts are, but just to give it for the tip credit, but for a simple example, as long as my employee receives $5 of tips for each hour they work, I can credit those $5, only pay them 10 still to get to a $15 minimum wage, assuming that was the minimum wage in the county we're in. These tip credits are not available to employers if the weekly average for tips is less than the tip credit for their industry. So if my employees are making on average, $1 in tips each hour, I can't say, sorry, I'm paying my amount, and if you didn't get enough tips, that's on you. That is not how the tip credit system works. The person is guaranteed, the employee is guaranteed to be receiving that minimum amount of tip credit. Now, tip credits, they're very fact dependent, even where counties might be the same in terms of their minimum wage. The amount you may credit for a tip may be different. I believe right now New York City has a different tip credit than Nassau, Suffolk, and Westchester. And of course, depending on the industry, whether you're, in a restaurant or say you are in some kind of hospitality business, like someone working in a hotel or a resort, these credits can change, which is why I have the link right there. Next slide, please. Now, here's some common issues with tip credit, and again, they are a little confusing, so I'd say this is probably the area where good faith mistakes happen the most. Just rule of thumb, if you're consistently being paid below the minimum wage with your tips, your employer likely is not following tip credit limits. Of course, I say likely because there always could be an exception, but most of the time that's going to be the situation. A big one here is if you are doing non-tipped work for 2 hours or more of your shift, then your employer will not be able to apply the tip credit. For example, say Brenda works at a restaurant as a server. Her manager asks her to spend 4 hours of her shift preparing rolls of silverware instead of waiting tables. As a result, she does not get any tips during those 4 hours because she's not waiting tables. Her employer cannot use a tip credit for Brenda on that day. That's why if you've ever worked in a restaurant, if they're doing things the right way, they're very meticulous about how long people are spending doing anything besides running food or waiting tables. Next slide, please. So next we're going to talk about overtime payments. Most people know what overtime is, but just in case, with some exceptions, when an employee works over 40 hours in a week, they'll be entitled to overtime pay. For the 41st hour onward, the employee will be entitled to pay that is normally 1.5 times the normal rate. There are some exceptions to that. And importantly, overtime payments need to be calculated weekly, no matter how often you normally get paid. A little fun fact about overtime payments, I'm a nerd about this stuff, is the reason that overtime was introduced into the law was because there was such a high level of unemployment that the government wanted to figure out a way to limit how many hours they would have businesses would have their employees work, so they'd have to hire more people, essentially incentivizing them to hire more people so they wouldn't have to pay as much money overall. Didn't really work out that way. Next slide, please. So an example for an overtime pay, and an example of how people tend to slip around it. So Billy gets paid every other week. Billy usually works 35 hours a week. On 1 week, his job is understaffed, so he works 45 hours week 1 and works as usual 35 on week 2. To avoid paying overtime, Billy's employer inputs in their payroll system that Billy worked 40 hours week 1 and week 2, resulting in no overtime being paid out. Now, no matter what your frequency of pay is, overtime is calculated by week. That is just the way it is in the law. Next slide, please. Next is illegal deductions. This is another one that usually occurs in small businesses. Essentially, unless a deduction is being done for the benefit of the employee, and notice is given to the employee in writing ahead of time, an employer cannot deduct money from an employee's wages. A great example is if there's an amount getting taken out of your wages for union dues or for a health insurance plan. An impermissible example would be payment being deducted because an employee, failed to convince customers that purchase a product that was about to spoil, or they accidentally ruined a product. These sorts of things cannot be deducted from an employee's paycheck. Next slide, please. And now we have frequency of payment. Again, this is more of a smaller business issue because a lot of larger companies will use a somewhat automated payroll system. It varies industry to industry, but generally, an employee must be paid at least twice a month. The default is to be paid weekly, and a business will generally have to get a special permit to pay less frequently than that. But even then, generally, it will be at least semi-monthly. Now, a common situation in a smaller business, an employer will say that, things are tough, and that if an employee wants to keep their job, they'll need to wait longer than usual to get paid. Sounds illegal, is illegal. Can't do that. Next slide, please. So, we've gone through there's other types of violations, like break time, spread of hours, sweet. We'd be here till tomorrow if we went through all of them. So that's as a general idea of some of the most common issues we have. So you suspect your employer is committing one of these violations. What can you do? Well, there's a few options. Of the first one, if you're a member of a union, the union likely has a process in place to adjudicate these issues. And part of your union agreement may be that you can't take out these other tasks, so you may want to consult whatever contract you're a part of or speak to your union representative. The second way you can do it is contact a private attorney. You might have claims under the Fair Labor Standards Act, which is the federal statutes that govern these issues, or the New York State Department of Labor or New York State labor laws. This option generally will cost money. And now the last option, and the one that, as John had made reference to before, we may be able to help somebody with, is we can submit a complaint to the New York State Department of Labor. The Department of Labor will investigate your claim and bring an administrative proceeding on your behalf if they find cause and can't get the employer to comply with less formal methods. Where was I here? Legal Services of Long Island will be able to help eligible Nassau County residents who wish to take this route by helping to gather and organize initial documentation to ensure the investigative process goes as smoothly and as quickly as possible. Like anything, the more you can give them up front, the less time it will take them to investigate the claim and make a determination. Next slide, please. So, if you decide you do want to go down this route, what does that look like? Well, first, you file a claim with the Department of Labor via their website. The Department of Labor will determine if you are eligible for their investigative process. If you are, you will be assigned a case number. Then you must wait for an investigator to be assigned to your case. From there, the process will depend on what kind of investigation needs to be done, the information the Department of Labor needs, and how cooperative the employer is with the department. I've heard horror stories of Department of Labor employees having to physically show up to businesses and ask to look at their books. Next slide, please. From there, if after the investigation, the Department of Labor believes there was a violation, they will try some less formal methods to get the employer to pay what they owe, and if they can't, an order to comply will be issued to the employee, and the Department of Labor will attempt to get the employer to pay up. And now an employer can attempt to contest the order to comply by requesting a formal hearing, and at that point you go through what is a typical hearing process where there's an administrative law judge who will review the evidence, hear testimony, and eventually issue a decision. If no hearing is requested by the employer, but they don't reply to an order to comply, they just kind of ignore it, at that point the Department of Labor will issue a money judgment and attempt to enforce that judgment. Now, and this is important, if the Department of Labor decides there was no violation, but you believe that there was one, you could still file a suit with a private attorney. The Department of Labor's investigation does not toll the statute of limitations, however, on private claims, which is very important to know. Next slide, please. So, what is that? Statute of limitations is essentially, if you don't know, it is the time you have to bring a claim on something. So the New York State Department of Labor will accept complaints within 3 years of when the wages should have been initially paid. New York State labor laws allow for a 6-year statute of limitations. And finally, the Fair Labor Standards Act, the federal law, will accept the statute of limitations is 2 years or 3 years if you can prove it was a willful violation, essentially meaning if you can prove that the employer knew they were violating the law and they did it anyway. And I believe that's it. Questions?
Does anyone have any questions? I just wanted to, seems like there was some confusion with the poll. Jacob and John, can you just go over one more time the minimum wage versus like the tipped? So like there's the non-tipped workers and then the tipped workers.
Sure. So the minimum wage should be, the minimum wage is the same for tipped workers and non-tipped workers. So just again, let's say it's $10 for the sake of simplicity. However, if you're a tipped employee, your employer may only be on the hook to pay $7 of that $10 if the amount you make in tips makes up for that extra 3 every hour. It's a little confusing. It kind of gets shuffled around. Tip credits don't reduce the minimum wage, they reduce how much the employer has to pay out of pocket.
Okay, thank you. Does anyone else have any other questions?
I had a few actually. Is it required for the person who's working and gets tips to let their employer know what they're getting as tips? And what about tip sharing? I know some of the restaurants still do that, where it doesn't matter if you're a good waitress or not a good waitress, if this, you pull together. Is there anything laws about that? I mean, what is the requirement as far as the person, other than making sure that she notifies or he notifies on their taxes that they're getting tips. Like, is there any other requirement that they have to notify their employer? Like, how does their employer know what they're getting as tips as far as the tip credit goes? Or it's just standard?
You do need to report your tips to your employer.
You do?
Yes, specific for this exact reason, to make so that they can ensure that the tip credits is being followed properly. This is speculation, but I would hazard a guess that most of the time tips are not reported properly. It is most of the big employment actions you see specifically in the city tend to be class actions regarding tip credit issues.
Mhm.
Just because the amounts tend to be so small that it's not worth complaining about a lot of the time.
Right, right.
And I'm sorry, Kevin, what was the other question you had?
No, I just wanted to know what the requirement was for, that do they have to notify the employer as to how much they're getting as far as tips go? And I'm assuming that happens also in the hairdressing industry and places where they're getting tips, obviously, and if they're also required to, I get a lot of calls through the Legal Support Center on tip questions. I also get calls regarding undocumented individuals whose employers are not paying them the for overtime, not paying them minimum wage, kind of holding over their head that that they're not citizens, and whether or not their employers are actually reporting that they work there. But that's like a whole nother section of that. Whether or not they're citizens, just so I know going forward, they're still supposed to get paid the correct amount if they're here, right?
Absolutely, that is a very, very common issue, is in its fear that if you attempt to advocate for yourself, that you will be reported on any kind of immigration status. And funnily enough, as to specifically the hairdresser thing, a lot of barbershops, salons lately have been attempting to circumvent this exact issue by sort of classifying each of their stylists or barbers as independent contractors and you're charging a fee for the chair. That they tends to be the way they talk about it. So it's an interesting development that's been happening in the last 15 or so years.
Okay.
Kathy, I think your other question was about tip sharing and whether
Oh,
employer.
yes, tip sharing. I
So-
hear every once in a while that some places do tip sharing. Is that legal?
So the tip sharing, and Jacob, you can correct me if I'm wrong, but I believe tip sharing is allowed, but the employer cannot participate in that tip sharing. So employer can require their staff to do a pooling or a tip sharing system.
They can't require them to
But
do it.
They can require them to do it if they, but the employer cannot participate, take. the-
Getting a piece
Yeah,
of that tip
yeah,
sharing.
I
That's
know there
under
was like a
your
local ice cream shop that
Yes.
took all of the tips from the high school students who were working there. And I think one of the moms made a complaint with the Department of Labor.
Thank you. Thank you, guys.
So Bob Scanlon, you have a question?
Yes, and I do apologize if Jacob already went over it. I did have to step away, take off my headphones a couple times. And actually, I think Kathleen sort of touched on the topic. And granted, I know with immigration, everything's just so up in the air, so I'm not asking for specifically that angle. But in general, retaliation, I'm assuming there's something built into the process for it. I guess I'm just wondering. You know what I'm saying? So either retaliation in some indirect way, or even just directly that employer finds out a complaint is filed and they just fire the person like immediately, right? Like, how does that kind of thing come into it?
It didn't get covered here because that is less a wage and hour issue and more a employment rights in general issue, but there is both a complaint process and a private cause of action for retaliation if a person complains to the Department of Labor about a wage and hour issue or brings a private action. So either one, there is a mechanism to deal with retaliation.
No, I got that, Jacob. I guess I apologize. I should have asked something more specific. My apologies. Is there anything, let's say, in like the penalty phase, or however, that when is there any consideration in the wage and hour process, right? Like, so if the complaint is filed and you submit an affidavit or documents showing retaliation occurred, is it at all factored in, or is it, like you're saying, just totally private action, hire an employment lawyer, etc.?
No, as I said, there is an administrative process you can go through with the Department of Labor, as well as a potential private cause of action.
My apologies, Jacob. I totally misheard that. Thank you so much.
No problem.
And there's a question, I'm just typing the answer now since I figured it's probably better for people to see it and just hear it about the tip credits amount. So I'm just typing that up, but to answer the question, it is $275 for tipped service employees in New York City, Long Island, and Westchester. And then it's $550 for tipped food service workers for the same areas, New York City, Long Island, and Westchester. There's a different amount for upstate New York. And I'll be putting that in the chat.
Thank you, John. There's also a question, are pool tips shared after a business day or shift regulated? I'm not sure what that means. Do you see the question?
I do. Gordon, I do see the question. I am unsure. My understanding is that generally it would be calculated into payroll. Any tips that are pooled by the management of the restaurant, but I can't point you to a regulation on that right this very second, but I can definitely find that for you.
Okay, and then we have Ms. Gonzalez. So if an employer states on a hiring letter that overtime is over 40 hours, but verbally states they will not pay for overtime, and fixed time card daily to change hours to reflect not more than 40 hours a week.
I mean, that would be a great example of the way that employers will attempt to circumvent overtime laws. Yes, that's almost the textbook example.
Okay. And then Ms. Rodriguez says, can you please give us an idea on how fast the New York Department of Labor would resolve a worker's complaint on overtime or underpayment of wages, for instance?
The answer is unfortunately that it depends. If the situation is such that the Department of Labor asks for documents to be produced by the employer gets those documents, and those documents reflect that these that what was alleged occurred, shouldn't take too long, maybe 4 or 5 months from once investigation starts. If the situation is such that the person's a little more sophisticated, the employer's a little more sophisticated, and they are making their records not reflect the reality of the situation, and the Department of Labor will need to start investigating by interviewing employees and getting statements, then it'll take a little longer.
Okay, does anyone else have any questions? Well, if you do, feel free to, if you think of anything after the presentation, feel free to email me and I can pass it along to Jacob and to John. But Ms. Gonzalez also says, to clarify, can the employer change the time card without my consent?
I think the best general answer there would be that an employer cannot alter an employee's time card such that it will not reflect the actual hours worked.
Legally.
Yes, legally. Well, they sure can do it.
Yeah, but it's not legal. Okay, any other questions? Okay, great. So like I said, if you have any other questions, I can always pass them along to John and Jacob. So thanks so much for joining us. Wait, we have one more question here. Hold on. Is this a correct statement of credit for tip workers in New York City, Long Island. WX is $5.50 for food workers and $2.75 for all others.
I believe that's accurate. In the presentation, there is a link, Barry, to the most recent chart by the Department of Labor showing all those breakdowns for you.
Okay. Okay, another question. Can you clarify if workers, employees, and nonprofit organizations can volunteer some of their hours so they don't get paid overtime?
I'm actually not sure on that, Dawn. I mean, I would imagine that, there's no law against doing whatever you want to do with your time. So if you want to volunteer extra time to, table with your non-for-profit or anything like that, that isn't against the law per se, but I'm unsure how it interacts with overtime laws. I can look into that.
Thank you, Jacob. Okay, any other last questions? Okay, great. So, once again, we have another presentation next week about applying for SSI for children. So feel free to join us next week or on April 9th when we have our presentation about our ICANN unit, which is the folks who are managed. I can't even think what it was, managed care plans. Okay, so thanks so much, and we will see you again. Have a great day.